Welcome back to the Deep Dive, where we commit to giving you that intellectual shortcut to understanding some pretty complex concepts.
We do the reading so you don't have to.
Exactly. We take a stack of sources, articles, legal docs, and we pull out the most important nuggets of knowledge, all tailored just for you.
And today, we are really sinking our teeth into a big one.
We are. It's a legal concept that sounds, purely technical, but it dictates the reality of ownership in almost every corner of your life. We are talking about vesting.
Yeah, it's a concept that's often misunderstood or maybe just narrowly applied. People hear vesting and they immediately think, oh, stock options, my 401k.
Right, startup culture stuff.
But it's core power. It stretches back centuries in property law. Vesting is the precise mechanism that determines who legally owns what, when, and this is the most crucial part, how those rights, once you get them, are protected against anyone else's claims.
Okay, so you're saying it's the difference between earning something
Right.
and having the secured permanent right to that thing.
That's it. That's the entire game.
Exactly. So our listener, the curious learner, has tasked us with unpacking this single, powerful legal idea across its whole spectrum.
Right.
We're going to hit inheritance, retirement, startup equity, and even local zoning law.
A broad sweep.
It is. Our mission today is to transform this dense legal term into something deeply practical. We want to give you those clear definitions and those aha moments that let you understand that crucial transformation from a mere expectation into a secured, unassailable legal reality.
Let's start right there with that transformation. The core definition, if you boil it all down, is that vesting is the point in time when rights and interests that come from legal ownership are acquired by a person.
Acquired.
And the immediate critical consequence of that moment of acquisition is the creation of what we call a vested right.
Okay, I want to pause on that distinction for a moment because it's so important. We're not just talking about the asset itself, the house or the money. We're talking about the right to that asset. How does the law define a vested right versus, say, just a conditional one?
A vested right is secured. It means it cannot be taken away by any third party. Not the person who gave it, not creditors, nobody. And that's true even if you, the recipient, may not yet physically possess the asset.
So it's like a legal guarantee of future delivery.
A guarantee of future or even present deployment. Once that right vests, the legal interest in that property or that asset is fixed. It's locked in.
And that's different from a vested interest. I hear that term thrown around too.
It's related, but a bit more specific. A vested interest refers specifically to the title or the interest in the present or future possession of the property, but with the key condition. That title or interest can be transferred or sold to another party.
So if I have a vested right to a future asset, that claim is strong enough that I could, in theory, sell that future claim today.
In many contexts, absolutely.
Wow, okay.
Because the right is secured and it's transferable, it has a present-day value, even if the physical asset isn't in your hands yet. It all comes down to that legal certainty.
That idea of an irrevocable right is, well, it's powerful. And nowhere is that more fundamental than when we look at property ownership itself. Let's move into our first section and really cement this foundational concept by looking at vesting in general property law.
Right. So we need to reemphasize here that vesting in this context is strictly about acquiring legal rights and interests that arise from the ownership of property.
It's not about the money yet. It's about the dirt.
It's about the dirt.
Yeah.
And if that right or title to present or future possession can be transferred, we classify it as a vested interest.
The sheer legal power here, I'm still wrapping my head around it. You can have a secured, legally protected right over something you don't physically possess.
Exactly.
It separates the legal reality from the physical one. That's a deeply nuanced idea.
Let's make it concrete. Let's use a really relatable example from real estate. The concept of an easement. This is where the term to vest literally creates an entitlement to a privilege or right over someone else's land.
Okay, so an easement is the recognized right to use another person's property for a specific purpose, right? Like running a utility line or just for access.
Precisely. So let's imagine a classic case, something you find in old legal sources called prescription. For years, maybe decades, you have regularly, openly, and unrestrictedly used a specific corner of your neighbor's undeveloped property.
A shortcut.
A shortcut across their field to reach a public road. You do it every day. They see you do it. Nothing is said.
So how does the law determine when that continuous use turns from just, trespassing that they tolerate into a secured right? Is there a standard threshold for that?
There is, but it varies significantly by jurisdiction. Usually there's a statutory period, commonly ranging from 10 to 20 years, during which the use has to be continuous, open, and what the law calls adverse, which just means without their explicit permission.
So you're not renting the path from them.
Correct. You're just using it. And once that specific time limit is reached, that privilege, that right to cross, becomes vested by prescription.
So even if the neighbor suddenly wakes up after 21 years and decides they want to put up a fence and stop me from crossing their lawn, they can't legally do it.
They cannot. And that is the critical implication of vesting in this context. It's a huge deal. The original owner retains full physical title and possession of their land, but they can no longer prevent you from exercising that secured right.
Right.
The right has become irrevocable. It's an unassailable interest in the property itself, even though you don't own the property. It's a fundamental legal shield protecting established use.
So understanding this core legal definition, the creation of an irrevocable right through time and condition, that's the key.
Right.
Whether we're talking about a dusty tract of land or a block of stock, the legal mechanism of moving from an expectation to a certainty is exactly the same.
It's the same core principle applied in different worlds.
That clarity on secured rights sets us up perfectly for Section 2, where the whole concept of certainty becomes, well, emotionally and financially critical. I'm talking about vesting in inheritance. Here, the challenge is that the certainty we're looking for often depends whether the beneficiary is, certain and alive at a very specific legally defined moment.
We are squarely in the realm of wills, trusts, bequests, and the intent of the testator. That's the person who created the will. And the sources are really clear that not all bequests vest immediately upon the death of the testator. They can be conditional.
And the most practical, common use of this conditional limbo relates to a time requirement. It's called the conditional bequest rule.
Yes. A standard clause in, I would say, most modern wills specifies that an heir must survive the testator for a set period. Often it's 30 days, 60 days, sometimes longer, in order to inherit.
And the will would also say what happens if they don't make it that long, right?
Oh, absolutely. It details where that share goes instead.
To the curious listener, this might seem like unnecessary red tape. I mean, why impose a delay on transferring wealth? Why not just transfer it immediately upon death?
Right, it feels like an administrative hurdle, but the why is driven entirely by avoiding two major sources of legal and financial friction.
Okay, what are they?
First, disputes over the sequence of death. In a mass accident, for example, a car crash, a fire involving multiple family members, it can be incredibly messy and, frankly, heartbreaking to establish who survived whom, even by a minute.
I can only imagine.
So if the will simply says to heir A, and heir A dies seconds after the testator, that complicates the entire estate distribution. Many jurisdictions have adopted something called the Uniform Simultaneous Death Act to help, but setting a survivorship period just eliminates the need for expensive, time-consuming litigation trying to prove the exact sequence of events.
So you're not in court arguing over coroner reports?
You're not. It prevents the estate from having to be opened twice in rapid succession based on the slightest difference in the moment of passing.
Okay, that makes sense. And the second reason?
Second, and this is crucial for significant wealth, it avoids paying estate taxes twice in rapid succession. This is what's known as double taxation, or the stacking of estate tax liability.
Okay, walk us through that process, because that's a key insight for you, the listener.
Okay, so if the asset vests in heir A immediately upon the testator's death, and then heir A dies 30 days later, that asset is now legally part of heir A's estate.
It has to go through probate all over again.
All over again, and potentially trigger a second round of state or federal estate taxes upon its transfer to heir B, who is heir A's ultimate beneficiary. By making the inheritance contingent on surviving, say, a 60-day period, the inheritance never legally vests in heir A.
It just skips them.
It skips them entirely. It goes directly to heir B, saving the family from 2 probate proceedings and potentially massive tax leakage.
So the moment of legal certainty, the vesting is delayed on purpose to manage risk and minimize the administrative burden.
Exactly. The actual heir can't be determined with certainty until that 60-day period expires. Until then, the right is not vested, it's merely contingent.
And this leads directly to a more complex property law idea you mentioned, future interest and contingent remainders.
It does.
Let's unpack that structure. This sounds like old-school property law, like something out of a Dickens novel.
It absolutely is. The classic structure involves 2 transfers. You give person A a life interest in a property, allowing them to use and enjoy it until their death, with the remainder going to person B.
So A gets to live there now, B gets it later. A has present possession. B has a future interest.
That's the setup.
So if A is, guaranteed to eventually die, and B is alive and identifiable, wouldn't B's remainder automatically be vested? I mean, it's a sure thing eventually.
Not always. If B is alive and identifiable, and there are no other conditions other than A's death, then yes, B has what we call a vested remainder. But when that remainder to B is contingent, the right has not vested.
Give us a concrete example of a contingent remainder. What makes it contingent?
Okay, consider this. A trust specifies the income from a property goes to person A for life. The remainder then passes to the children of person A who survived to the age of 21.
Okay.
Now, if person A has no children, or if their only child is currently 15, that child is not guaranteed to reach 21.
Right. Anything could happen.
Anything could happen. And the group of beneficiaries isn't fixed yet. The recipient is uncertain. And until that uncertainty is resolved, until the child turns 21, or until person A dies without any qualified children, the remainder interest remains unvested. Those potential recipients have no secured, transferable legal right to the property yet.
I see. So the legal mechanism of vesting is designed to remove all contingency, leaving only certainty. Until the exact person or entity receiving the asset is guaranteed, the clock for vesting hasn't struck midnight.
That's a perfect way to put it.
Okay, we've established this principle of unassailable rights through time and condition. Now let's transition that legal certainty from, the courtroom and the grave to where most of us encounter vesting on a daily basis, the world of contracts, compensation, and loyalty.
This is Section 3, vesting in employment. And this is where vesting moves from sort of theoretical law into a really practical, powerful tool for organizational strategy. It's all about structuring deferred compensation and rewarding long-term commitment.
The sources outline three main contexts here: retirement plans, ownership in startup companies, equity and profit-sharing plans. We'll start with 3.1, retirement plans, specifically employer contributions to things like 401ks, annuities, and pensions.
The foundational difference here under U.S. law and the Employee Retirement Income Security Act, or ERISA, is the difference between your money and your employer's money.
A very important difference.
A very important difference. Employees are fully vested in their own salary deferral contributions from day one. That money is immediately, irrevocably yours. You earned it, you put it in, you own it. End of story.
So it's the employer's contributions, the matching programs, that are subject to this loyalty structure.
Precisely. Those employer contributions are conditional. They're governed by specific vesting schedules. But the moment any portion of that employer money vests, the core protection kicks in. The employee has an absolute, unassailable right to that amount. It is secured.
What's the ultimate protection here for the employee? Let's say the company hits hard times or even files for bankruptcy. Is that vested money still protected?
Absolutely, 100%. Once vested, the employer cannot reclaim that portion, nor can creditors use it to satisfy the employer's debts. It sits in a protected, separate trust. This is a fundamental consumer protection built right into ERISA.
But the unvested part is a different story.
A completely different story. Any portion that is not vested remains conditional and may be forfeited upon certain conditions, usually termination of employment or just failing to meet that scheduled loyalty requirement.
So the non-vested portion is basically the employer's tool to enforce the loyalty contract.
Yeah.
And these contracts are defined by the vesting schedules. Let's go over the two main types that ERISA allows.
The two schedules are the cliff model and the graduated model. Cliff vesting is all or nothing. It's based on hitting a single date. For example, ERISA says that for defined contribution plans, like a 401k, the maximum cliff period allowed is 3 years.
3 years. So if the plan uses a 3-year cliff,
You are 0% vested for 35 months and 29 days. And then boom, on the 36th month, you become 100% vested instantly.
that is a stark incentive model.
It is. The alternative is graduated or graded vesting. Here, the vesting occurs pro rata over time. ERISA allows for a maximum graded schedule of 6 years. So an employee might vest 20% after year 2, 40% after year 3, 60% after year 4, and so on, until they're fully vested after 6 years.
So you're gaining a secured portion annually. It softens the financial blow if you leave early compared to the cliff model.
Much softer. You walk away with something.
I want to introduce a critical question here, just to probe the underlying structure. The employer incentive is clear. They only reward the most loyal employees, which theoretically lets them afford better matches for those who stay.
Yeah.
But what's the ethical or practical risk of the cliff model? I mean, if a highly valuable employee leaves one day before a 3-year cliff,
They get nothing.
they get nothing. Doesn't the company benefit unduly from 3 years of unrewarded labor, essentially clawing back the full benefit of that matching contribution.
That is the fundamental tension embedded in the cliff model. From the employee's perspective, yes, that can feel extremely punitive. But the company views the employer contribution as a strategic retention tool, not a right earned through hourly labor. They argue that the promise of the match was conditional on sustained loyalty. The benefit is designed to incentivize the future years of employment.
So if you leave early, you're breaking that deal.
You're choosing to forfeit that deferred benefit. And what happens to that forfeited money is interesting. It typically remains in the plan to be reallocated among the remaining loyal participants, or to reduce future employer contributions. It just highlights that vesting is fundamentally a risk-shifting tool. The employee bears the risk of forfeiture until the right vests.
That clarifies the contract, even if the outcome can feel pretty harsh. Now, let's move to where this gets even more complex and, frankly, more relevant for the modern workforce. 3.2, vesting in startup company ownership.
Yes, the world of equity.
Wow.
Startups use vesting for grants of common stock or options for key participants, founders, employees, contractors, advisors. The purpose here is intense. It's about aligning incentives with long-term commitment.
Making sure everyone rows in the same direction.
Exactly, and ensuring the reward reflects the total extent of the contribution, and crucially, preventing former participants from retaining ownership that is no longer being actively earned.
We need to dedicate some real time to contrasting the two main equity mechanisms. Let's start with the most common one, stock options.
Okay, stock options vesting is generally the easier mechanism to understand. The employee, the grantee, receives an option, which is the right, but not the obligation, to purchase a block of common stock at a set price, the strike price.
And this option is granted up front, but vests over time.
Correct. So what's the rule once the clock starts ticking? The employee can only exercise the option, which means, buy the shares for the vested portion. If you have an option for 40,000 shares over 4 years and 10,000 have vested, you can only buy those 10,000 shares. The mechanism is a simple status change. The option moves from fully unexercisable to fully exercisable based on the schedule.
And what happens when your employment ends? This is a huge point of confusion for people.
A critical point. Almost all option agreements have what's called a post-termination exercise period. The entire option, vested and unvested, is often lost if the employee does not exercise their vested options within a very short window after they leave.
Well, short is short.
Typically 90 days. That creates an immediate ticking clock and often requires the departing employee to find immediate capital to purchase the shares before they lose the right forever.
That places a huge burden on the departing employee. You have to make a quick investment decision on a company you just left based on its current value.
A huge burden, absolutely. Now let's look at the other mechanism, which is for common stock grants. This is most often used for founders or very early key employees. The function is the same, rewarding loyalty, but the legal mechanism is fundamentally different. It relies on a repurchase right.
Okay, I really want to isolate that distinction. The key here is that the right to buy back the stock is the central element, not the ability to exercise an option. Walk us through that process in detail.
Right. So in the founder context, the individual typically purchases their entire share allocation, let's say 1 million shares, at a nominal or par value very early on, often for pennies. They own the shares immediately. They're in their name.
So they're a shareholder from day one.
They are. However, the company simultaneously retains a repurchase right to buy that stock back at the same nominal, low price should the individual leave the company within the vesting period.
So ownership is immediate, but it's totally contingent.
Yeah.
The shares are in your name, but the company has this massive legal claim on them.
Exactly. Vesting, in this case, occurs as that repurchase right diminishes over time. With every month that passes on the schedule, the company's right to buy back a pro rata portion of the stock just vest. It vanishes.
It burns off.
It burns off. Once the stock is fully vested, the company has lost the right to repurchase any of those shares at that nominal price. The founder's ownership transforms from ownership with a claim to unassailable ownership.
This is a major insight for you, the listener. Options vest by becoming exercisable, whereas common stock vests by the company's right to claw it back diminishing. It's like an inverse vesting process.
It is, and this leads to a critical tax component, especially for founders, the 83B election. Because the founder buys the stock up front and it has immediate value, the IRS views the difference between the purchase price and the stock's fair market value, or FMV, as potential ordinary income when the shares vest.
That sounds like a potential tax nightmare if the company becomes a unicorn 5 years later and your stock is vesting every month.
It's a disaster. The 83B election is a tool that allows the founder to tell the IRS, I elect to pay ordinary income tax on the low nominal value of this stock now at the time of the initial grant, rather than paying it later when the shares vest and are likely worth much, much more.
And you have to do that right away.
You have to do it within 30 days of the grant. It's a very strict deadline.
So the 83B election allows the founder to lock in their tax basis early, turning all future appreciation into lower-taxed long-term capital gains, provided they hold the stock long enough. It's intrinsically linked to the vesting schedule and that repurchase right.
It's completely inseparable. It shows how vesting isn't just about loyalty. It's about establishing crucial financial and legal milestones.
So moving to the schedules themselves, what is the nearly universal standard for startup equity vesting in the U.S.?
The standard remains the 4-year pro rata monthly vesting over the period, combined with a 12-month cliff.
The one-year cliff.
The 1-year cliff.
Right.
This means you get no vesting at all for the first year. You hit the cliff date, your first anniversary, and 25% of the grant vests all at once. After that, vesting happens incrementally, usually monthly, for the remaining 3 years.
We already talked about the incentive. It filters out people who aren't fully committed. But structurally, why do companies prefer giving one large initial grant that vests over time rather than, say, granting smaller, fully vested chunks every year?
Yeah, that's a good question. The large initial grant is preferred for several reasons, beyond the 83B tax advantages we just covered. Administratively, setting up one large grant is just far easier to track than managing continuous periodic small grants. For the employee, it sets the psychological tone of being a long-term partner, not just a seasonal worker.
And for the company.
Most importantly, from the company's valuation perspective, establishing the initial grant price and the vesting schedule up front makes future valuations, financing rounds, and compliance much, much cleaner and more predictable.
Got it. Let's quickly wrap the employment context with 3.3 vesting and profit-sharing plans.
Right, these are less common today, but they still exist. Standard vesting here is usually much longer than for retirement matching, sometimes up to 10 years.
Wow, a decade.
A decade. However, these plans often integrate a little flexibility, allowing for limited vesting if the employee retires or leaves on good terms after an extended period of service. They end up acting almost like a supplemental pension. But the key takeaway remains the same across all 3 of these employment contexts. Time and performance secure the right to deferred compensation.
Okay, we've established the why and the different mechanisms. Now let's turn to Section 4, the fine print vesting arrangements and terminology. This is the toolkit the listener needs to scrutinize any compensation or legal document they might encounter.
Right. We're moving from the high-level concepts to the specific vocabulary used in legal agreements. We're going to transform the abstract into concrete timelines.
Let's start with the fundamental duration, the vesting period.
This is simply the total required length of time a person must wait until they are capable of fully exercising their rights, and those rights can no longer be taken away. If you are on a 5-year graded retirement schedule, the vesting period is 5 years. Simple as that.
And, as we know, vesting rarely happens all at once. So when some rights are secured and some remain conditional, that's partial vesting, and it's determined often pro rata, or proportionally, across the timeline.
Which is all visualized in the vesting schedule. This is the formal table or chart that shows the portion of a right that becomes vested over time. These schedules typically progress in what's called a stair-step fashion, with equal or unequal portions vesting on specified dates. It could be daily, monthly, quarterly, or annually over the life of the vesting period.
Let's drill down again on the most important structural element in equity vesting, which we've already touched on, the cliff.
So we define the cliff formally as an intentional absence of vesting steps at the very beginning of the schedule. This results in 0 vesting for the initial period, say 12 months, followed by a cliff date where the portion that would have been earned during that initial period vests all at once.
It's a mechanism of elimination.
It is. It ensures that resources are only committed to proven long-term participants. If you leave a day before the cliff, your total vested equity is 0.
That risk is crystal clear. Now let's look at the structure that speeds things up. Accelerated vesting. This is when all or a major portion of your unvested rights suddenly vest because of a specified event. This is where contracts can protect the employee from market forces or management whims.
Correct. Accelerated vesting is essentially an escape hatch for the employee. The common triggers are usually tied to a lack of job security or a change in company control.
Can you break down the 2 main types of acceleration we see in these agreements?
We see single trigger and double trigger acceleration, particularly in startup equity. Single trigger means vesting accelerates instantly upon one single event. Most commonly, that event is the acquisition of the company by another entity, a change of control or COC.
Why is that a protection?
It protects employees whose options might otherwise become worthless or be subject to renegotiation upon the sale of the company, and makes sure they get rewarded for their work leading up to the acquisition.
Okay, and double trigger.
Double trigger is now much more common. It requires two events to happen for acceleration to occur. The first trigger is the change of control, the acquisition. The second trigger is the involuntary termination of the employee, usually without cause, by the new company, occurring within a set period after the acquisition, often 12 months.
That sounds like it offers better protection for the acquiring company.
It does. The acquiring company doesn't want all the valuable employees to cash out and leave immediately after the acquisition closes, which single trigger acceleration can encourage. Double trigger incentivizes the key talent to stick around post-merger, secure in the knowledge that if they are terminated, they will receive their full equity reward. It's a retention tool for the new owners.
Moving back to the regular timelines, let's just revisit the granular details of graded vesting variations.
Right. As we discussed, graded vesting is sometimes called repurchase vesting, meaning vesting happens year after year until it's fully secured. We can subdivide this into uniform and non-uniform. Uniform graded vesting involves equal portions each year, the simplest example being 20% each year for 5 years. The steps are predictable and equal, offering a steady retention incentive.
And then there's the more strategically interesting one, non-uniform graded vesting.
This features unequal portions, chosen by the employer to match incentive with specific business needs. For instance, a schedule might vest 10% in year 1, 20% in year 2, and then a whopping 70% in year 3.
Why would they do that?
This concentrates the largest reward at a critical milestone, perhaps the launch of a key product or an anticipated IPO date, giving the employee a massive financial incentive to remain committed through that specific high-value phase of the company's life.
This section truly is the specific toolkit the listener needs. By understanding the difference between a repurchased right and an exercisable option, and by knowing the triggers for single versus double acceleration, you can properly evaluate the risk and reward profile of any compensation package.
You can read the fine print with confidence.
We've spent the bulk of our time in the financial realm, but the concept of vesting is so foundational that it impacts non-financial rights as well. Our final application takes us outside the world of stocks and pensions and into local government and construction. The vested rights doctrine in zoning law.
This is a powerful legal shield. It really demonstrates how the core legal concept of vesting, the creation of an unassailable right, applies to the interactions between private property owners and the ever-changing landscape of government regulation.
Okay, so let's set this up. If a developer secures a permit for a 20-story building, and 2 months later, the city council passes a new ordinance restricting all buildings in that area to 10 stories.
How does the vested rights doctrine protect that developer? The vested rights doctrine is the rule that allows that owner or developer to proceed with the project according to the prior zoning provision. It effectively grandfathers their project in under the old, more favorable rules. They are protected against later adverse changes in municipal zoning.
But surely they can't just draw up the plans, stick them in a drawer, and then claim eternal immunity from new laws. What must the developer prove to show that their right has legally vested against the new ordinance?
That is the crucial threshold. The right only vests if the owner or developer has undertaken concrete action in reliance on the old zoning rules. Specifically, they have to demonstrate 3 conditions, all done in good faith by an innocent party, either under a valid building permit or in reliance upon the high probability of its issuance.
Okay, what's the first condition?
First, they must have shown a substantial change of position. This means they've done more than just conceptual planning. They've altered the legal or physical status of the property. They've started digging. Second, they must have made significant expenditures. This is quantifiable financial commitment paying engineers, architects, utility hookup fees, or purchasing non-refundable materials. Real money is out the door.
And the third condition?
And third, they must have incurred binding obligations. They have signed contracts with construction firms or suppliers that they cannot easily walk away from without a severe financial penalty.
Give us a hypothetical scenario where a developer tries to claim a vested right but fails one of those criteria.
Okay. Let's say a developer buys a tract of land intending to build a high-density apartment complex, which is legal under the current zoning. They spend $1 million on architectural drawings and soil testing.
That's significant expenditure.
That's significant expenditure, yes. And they sign a non-binding letter of intent with a builder, which is not a binding obligation. Before they receive the final building permit, the city council downzones the area, cutting the allowable density in half.
In that case, did the right vest?
Likely not. While they made significant expenditures, they failed to make a substantial change of position. They hadn't begun construction or done substantial site work, and crucially, they hadn't incurred binding obligations that legally tied them to the old plan.
So the letter of intent wasn't enough.
Not nearly enough. The courts tend to rule that financial expenditure alone, without a physical change to the land or a definitive legal commitment to build, is insufficient to override the municipality's right to update its rules for the general welfare. The right remains conditional until that commitment is legally cemented.
This doctrine is a perfect illustration of how vesting balances municipal power with individual fairness. It recognizes that once a citizen has committed substantial resources and changed their legal position in reliance on current law, the government can't just retroactively pull the rug out without legal consequence.
It protects good faith investment.
What an incredible deep dive. We have meticulously traced the power of a single legal concept vesting, from someone establishing a permanent right to cross a lawn,
To navigating complex inheritance taxes.
to protecting the hard-earned value of stock options in a fast-moving startup.
To synthesize the key takeaway here, vesting is the legal mechanism that transforms an expectation, a hope, a possibility, a contractual promise, into an unassailable, secured right.
A right that is shielded.
It's shielded against any third-party interference, whether that interference comes from an employer shifting business priorities, a family trying to mitigate tax liability, or a local government rewriting the regulatory rulebook. Once vested, the right is a legally secured certainty.
And that transformation into security is what fundamentally changes how we interact with time, risk, and commitment. Vesting is, at its heart, about confidence.
Yes.
If you know your rights are incrementally being secured, it allows you to plan further out, invest more deeply, and commit your time and effort with a greater certainty of future reward. It's what makes multi-year employment contracts and long-term investments viable.
It allows the legal system to put predictability back into the hands of the individual engaging in these long-term contracts.
And that leads us to our final thought for you, the listener, based on our discussion of modern equity practices. We noted the growing popularity of milestone-based vesting in startups as an alternative to the traditional time-based cliff.
Right, moving away from just time in the seat.
Exactly. So consider this. How does shifting vesting from time served to results delivered fundamentally change the relationship between effort and reward? If your equity vests only upon the successful launch of a product or the attainment of a certain revenue goal, does that make the right to future ownership more truly reflective of the value you created compared to simply waiting out a 4-year clock?
That's a great question.
Is that shift a truer expression of the spirit of entrepreneurial contribution? And what new risks does it introduce for the employee?
An excellent area for further exploration. It really challenges the core assumption that time is the only or even the best metric of loyalty and contribution.
Thanks for diving deep with us. We'll see you next time.